Hi everyone, I'm just going to give a brief analysis today of a small part of the Ombudsman's appearance at the recent Senate Community Affairs Committee Senate hearings. This hearing took place on 15 August 2023 and it was broadly about poverty in Australia, but the chair of the committee and others on the committee asked the Ombudsman about his recent report titled Lessons in Lawfulness, regarding unlawful income apportionment under Section 1073 B of the Social Security Act.
Senator Maria Kovacic and Senator Louise Pratt. So for the Hansard record, will you please state your full name and the capacity in which you appear today?
Ian Anderson, Commonwealth Ombudsman.
Thank you. So would you like to make an opening statement?
I'm here at your invitation, Chair. Happy to go straight to questions.
Terrific. Okay. Which I presume you know what I'm going to focus on to kick off. Yes, so I'll ask you about your recent report, Lessons in Lawfulness. Because just start off in terms of your decision to undertake that report. What was that based on?
So we started receiving complaints from clients of Services Australia back in 2021 who were noticing that when they'd asked for a review of a decision, the review was being delayed. Services Australia has an aim to complete reviews within 49 days, and people coming to us and saying it's been 6 to 12 months.
So I'm aware of a number of those people who had their claims, or rather their applications, to have a review by an internal ARO, as they're called, an authorised review officer, or an ARO, or a subject matter expert, an SME, delayed without any reasons. And interesting to note there that there's an internal aim within the agencies of a 49-day kind of period within which to review these matters that are applied to be reviewed, but that is not a legislative provision. So it just sits there as a kind of soft law goal within the agencies.
So we reached out to Services Australia to seek information, and from time to time they would say they're being progressed, and we'd keep reaching out. What we didn't realise was that in the background there was a process underway where Services Australia and DSS were looking at the particular provision, Section 173B of the Social Services Act, which provides for income apportionment.
So that's Section 1073 B of the Social Security Act. There is no 173B as far as I'm aware.
And they came to us in January of this year and said, we want to tell you some things about income apportionment. And we met with them in February, and we said we want more information. They gave us information at that point when they had told us that there's potentially 13,000 debts affected and another 87,000 debts that might be affected, so 100,000 debts. I thought it seems to be quite a significant issue, and it seems to be taking quite a while to decide how to proceed with it. So at that point, in March, I thought I want to do an investigation into this and understand more about, firstly, the legality of what's been done. So was that clear in itself? And then secondly, the question of how is it being administered? This question of there might be past debts, there might also be past underpayments, and what are the communications with people affected, things like that. So we've got another investigation still ongoing, which is about the administration part. But I wanted to do a short, sharp exercise looking at the question of legality, first of all.
So could you summarize?
So, the Ombudsman, Ian Anderson, has given evidence, or rather given information to the Senate Community Affairs References Committee here that it was effectively an own motion investigation following the revelation by the agencies to the Ombudsman in February 2023, that there was a problem going to the unlawfulness of the apportionment of income reports, be they from employers in the form of pay slips, or be they from recipients themselves in the form of reported income, that that data was being subject to the Section 1073B daily attribution of income rule, but that, as the agencies themselves advised the Ombudsman, there appears to have been a problem, and that the agencies appear to have almost conceded that what they had been doing since 2003 to 2020 was unlawful, and that they had identified a total of 100,000 recipients who are either affected or potentially affected, 87,000 of which had already had their matters determined and were in the past, seemingly, and another 13,000 of which had reviews on hold, frozen, as a consequence of the agency's adopted view that the questions raised by the reviews or the appeals were related to the unlawfulness that they themselves had identified through their own lawyers. So it took 2 years for this problem to be first raised in 2020 through to the 2023 concession, it seems, that there was a problem by the agencies to the Ombudsman.
Summarise for us what income apportionment is and why its use by Services Australia and the Department of Social Services was unlawful.
So, income apportionment, Section 173B was inserted in
1073B, just for clarity's sake.
2003, and what it does is it requires the apportionment of income within a 14-day instalment period to create a daily rate. So you take the income that's earned, received or derived in that 14-day period and divide it. So that's fine. But what was actually happening was it was being used to spread income across more than one instalment period, and that's the problem. Now, often that was happening simply because people didn't have clear records as to the correspondence between their income and an instalment period. So they might have had a monthly pay, for example. They might have had a weekly pay instead of a fortnightly. Or even if they had a fortnightly pay, it might not have corresponded with the fortnight that was the Centrelink instalment period. So what was being done was it was being spread across instalment periods. And the outcome of that, we have a worked example in the public statement, it could mean that people are assessed as being as actually earning more income in one instalment period than they did and earning less in another instalment period than they did.
So that is a fairly good explanation of the problem. The Ombudsman is using the language from the section itself in a way that's not as clearly done in the actual public statement, the Lessons in Lawfulness public statement. And that language is the language of instalment periods. An instalment period is the period in which an instalment of Centrelink benefit, i.e. a welfare payment, is made. And so welfare payments are generally made fortnightly on a 14-day basis. And so an instalment period will be the period within which the payment is made, and it will be made with respect to a 14-day cycle. And so, interestingly, the wording of the statute, section 1073B, is being used here, instalment period. But in the statement itself, the Ombudsman's statement, those periods are described as Centrelink periods.
Might not produce large amounts of difference in any one instalment period, but over a period of time, it could actually lead to a much more significant amount, which could be an underpayment or could be an overpayment. And of course, if it was perceived to be an overpayment, then that could lead to debt collection, or it could potentially lead to referral for prosecution. So those are very significant impacts for particular individuals affected.
That's right. So one way of thinking about it is as follows. If you earned, say, $3,100 in a single month consisting of 31 days, and your payslip simply said month of X, $3,100. It didn't give any information about when the income was earned, nor even when it was received. It just said that the income paid on a payslip, possibly handwritten by an employer who had actually responded to a Centrelink request to report income in an investigation, had written $3,100 for the month of X. If that was on a page, then Centrelink would say, okay, so you've earned $100 per day over the month. When that happens, given that a month consists of 2 fortnights, that person would have been regarded as earning $1,400 each fortnight. Roughly, Centrelink would say you earn $100 a day for 2 fortnights, which equals $1,400 a fortnight. So what that would do effectively is mean that you the recipient, earned $1,400 each fortnight, $100 a day, and therefore you were probably not entitled to any Centrelink income for either fortnight because, let's say the limit of earnings is $600 a fortnight before your entitlement's reduced to zero. Well, here you've earned $1,400 in the first fortnight and $1,400 in the second, so your entitlement's reduced to zero for both fortnights. But what if the actual income was received only in one instalment period, i.e. one of the fortnights in that month? Suppose that you earned that lump sum only at the end of the month when you did an intensive piece of work that meant you earned that total amount just in that second fortnight. That would mean that you were knocked out of welfare benefits for the second fortnight, but you were entitled to benefits for the first fortnight when you actually did not receive, earn, or derive any income. Now, that's the theory behind the way in which this can be incorrect mathematically. And when I say incorrect mathematically, I mean it can be incorrect both at the level of reality, because the money wasn't actually earned, derived, or received until the second fortnight, but also mathematically, because if you take it as being earned, derived, or received in the second fortnight, you cannot then mathematically divide it by 31 days or across 2 fortnights. You can't do that legally either, and that's what the provision said. You can, however, divide it within one instalment period. So if the money was earned, derived, or received within the second fortnight, Centrelink have a legal kind of rule that permits it to attribute that income on a daily rate across one instalment period, which would be the second fortnight. But they didn't apply that rule properly because the $3,100 could have reduced to a single 14-day period, and it would have lawfully been possible for Centrelink to reduce the $3,100 total of the month to a single instalment period. So 31 divided by 14. But it couldn't do 3,100 divided by 31, which was more than one instalment period and was in fact 2 instalment periods. So that's what's happened, and that's unlawful. The word unlawful here meaning that Centrelink did something. The rule says do X, and it did something that the rule doesn't say is possible. So there is no legal support, or there is no authorising legal provision that enabled Centrelink to do what it did. Therefore, it's unlawful. The word unlawful is usually used to denote an activity or an action that doesn't have a legal basis, or at least a secure, express legal basis. It's kind of different to illegal, which usually denotes conduct that is prohibited or proscribed by a positive express legal provision. Here, the problem is that there just isn't a legal provision making the calculation method adopted by Centrelink within the rules. It's like doing something in a sporting match that isn't expressly banned, but has never been part of the game. And the referee must say, hang on, where in the rule book are you permitted to do that? And if there is no discussion of it in the rule book, or if there is no permission granted, then the referee might say, well, I cannot allow that to happen. But that analogy isn't perfect because there's a slightly more detailed way of expressing it here, which is probably closer to the reality of the situation. It would actually be doing something that is part of the rules of the game, but with a new kind of component that isn't authorised. So, for example, in football, the soccer version of football, you are allowed to use your feet to kick a goal or to kick the ball, but not your hands. What if you put boots on your hands and started trying to kick the ball with the boots on the hands? one referee might say, technically that's permitted because it's kind of like kicking. But I think most other referees would say, well, really, you're doing something outside the rules, even though there's some technical argument to be carried out here. And so I think that's where we're at. It's quite clearly unlawful, and in the legal world, it's less debatable than my example of the boots on the hands. But it's not prohibited either, what they did, in an express way by the law. But the law doesn't go around prohibiting everything that it imagines is possible. And so there's a high premium on permission being necessary. And here permission was not granted to do X. It's an official administrative function of Centrelink as the relevant service agency of the two departments, the Department of Social Services and Services Australia. And they were doing something that is not permitted by the Social Security Act. And here's the real catch. It is not permitted by the Social Security Act, but it was done pursuant and under the kind of aegis, or under the kind of camouflage, as it turns out, of doing something that was legal. So if you say, I'm kicking the ball with my feet, while actually kicking the ball with your hands with boots on, you're not really doing what you say you're doing, are you? And that's the problem.